Hi, welcome to the webinar today. My name is Alexandra Alvarado. I'm the Director of Marketing and Education at the American Apartment Owners Association. Today, we have two expert attorneys in New York that are going to go over your COVID landlord legal survival. They're going to talk about some of the newest updates. We had them on with us earlier this year, so I thought it'd be a good idea to bring them back because so much has happened and continues to happen in New York specifically. So we are thrilled to have Justin and Robert Friedman with us today. I want to give you a little bit of background about them before we begin. Robert here, he is a lifelong New York resident who earned a BA from SUNY Buffalo in 1975. So he's been practicing law for 42 years and has written 8 books on landlord-tenant law, small business law, DWIs, and Medicaid law. So he's been in all types of different law, but now he focuses on landlord-tenant law and firmly believes that being an active participant in the community is necessary for a successful law practice. So Robert is here today and he's going to start the presentation. Then we're going to have Justin come on. He earned his JD from the Catholic University of Columbus School of Law in 2017 with a concentration in criminal law. And he is committed to utilizing the skills that he's honed over the course of his previous career to best serve his clients in New York. I'm so thrilled to have both of you today. Before we begin, just one quick thing. We are going to have questions that will be answered throughout the presentation. So if you have questions, please put them in the question and answer box and not the chat because we don't want to miss your question. So that will help us to keep organization. And also we're going to send you the full recording and the PowerPoint slides tomorrow. So keep an eye out for that. If you are registered for this webinar, you will get an email automatically with the recording tomorrow. So with that being said, I'm going to pass it along to Robert to get started. Thank you so much, Robert, for coming on again.
And thank you for hosting this webinar and welcome everyone. I just have a few warnings before we get started. This is not a substitute for legal advice. We're going to be providing general information and you need to consult with your own attorneys. Also, we were only talking about New York law here. This, what we're talking about, is limited to the state of New York, and the laws are constantly changing and subject to various interpretations. We have a tremendous amount of material to cover in just 1 hour, so we're going to try to condense that information. We will attempt to answer your questions through the Q&A feature of the webinar, and we will also remain after the webinar for about 15 minutes to answer your questions. And if you still have questions, then feel free to contact us. You will be sent a link to our website, which you can post questions on our contact forms, subscribe to our newsletter, and have access to the information on our WNY-Lawyers website, which has updates on landlords' rights, especially during these pandemic times. We have been consistently evicting tenants throughout the pandemic without landlords having to go to jail for violating their tenants' rights. As was said previously, the PowerPoint will be made available to you. The PowerPoint and video of this presentation will be sent to you. I've been presenting seminars for landlords ever since about 1985. And even back then when things were quite a bit different, the main theme is communication with your tenants and documentation. Just like everything else, if it isn't in writing, it never happened. So that's truer now than ever before. So communication is going to be very important. So even though the New York Tenant Protection Act of 2019, which went into effect in June of 2019, over 2 years ago, we still find that many of our landlord and property manager clients are not aware of this law. And it's especially important that you comply with this law if you want to be able to, first of all, quickly evict your tenants, and secondly, collect rent. So if you're not complying with the law, you could jeopardize and waive your right to security deposits, not able to collect rent, or have long delays in evicting tenants. And so just go over some of the highlights of the New York Tenant Protection Act of 2019, just as a refresher to many of you, and for others, it may be the first time you've heard about this, but there's some very important changes that were enacted in 2019 that affect your leases and affect the eviction procedures. Some major changes which are all in the favor of tenants. First of all, you must send a notice by certified mail when residential rent is past due 5 days. That was a new requirement, certified letter after the rent's past due for 5 days. And now for non-payments, it's a 14-day notice instead of a 3-day notice. Now it's very important that you're going to be complying with the Tenant Protection Act, because we're finding that it's often easier to evict a tenant as a holdover versus non-payment. So you need to comply with all these provisions. Another change was a notice of petition. A petition must be served 10 to 17 days before the court date. Prior to that, it was 5 to 12 days before the court date. Now, either party can request an adjournment of at least 14 days, so you can all show up at court on the court date, and the tenant can ask an adjournment of at least 14 days without giving any reason. That's the tenant's right. That's either party's right. Attorney's fees cannot be awarded if the tenant defaults and does not show up in court. In the eviction proceeding, you could still pursue attorney's fees in small claims court, but it would not be part of an eviction judgment. Warrants now give tenants 14 days instead of 72 hours notice to vacate. The tenant can terminate the proceedings by paying all rent due before the warrant is executed. That's the Tenant Protection Act of 2019, and Justin will be covering some additional requirements regarding warrants brought about by the COVID-19 provisions of the law. The warrants can be stayed and not executed for up to 1 year in hardship cases. Late fees are limited to the lesser of $50 or 5% of the monthly rent beginning the 6th day after rent is due. So beginning the 6th day that rent is due, you can charge late fees, but they are limited. You can no longer charge application fees, and credit report charges cannot exceed $20. Another thing that was codified by this act is that you have a duty to mitigate your damages as a landlord. So if a tenant moves out, breaks a lease 3 months into a 1-year lease, you are obligated to make best efforts to re-rent the apartment. You can't just sit back and let the apartment sit empty and attempt to collect from the tenant. Not that that's a good idea anyway, because as we'll discuss, most judgments against tenants are uncollectible. Now, one of the few defenses to a holdover eviction is retaliatory eviction. If you're retaliating against a tenant, and it used to be if you're retaliating against a tenant for complaining regarding a housing code violation or a building code violation, that would be a defense to you being able to evict the tenant. That's been expanded now. Retaliatory eviction has been expanded to include if you've made complaints of the conditions of the apartment to the landlord. That would be a defense to a holdover proceeding that the landlord is retaliating against the landlord for making those complaints. This K here is very important. As I said, especially in these times, it's very important as to how you terminate the lease. So prior to 2019, if you had a fixed term lease beginning January 1st, ending December 31st, the lease ended at a fixed term. You didn't have to give the tenant any advance notice. Tenant had to be out December 31st. I always advise landlords, however, to contact the tenant, see whether or not, to let them know whether or not, the landlord should let the tenant know whether or not they're renewing the lease. But anyway, we're finding the easier way to evict tenants may be as holdover. So you have to be sure you're complying with the 2019 law in terminating leases. So residential notices of non-renewal or termination of month to month, if the tenant's been there for less than 1 year, it would be on 30 days notice. Now that's if they've been residing there, even if they've been residing there with prior owners. Their residence includes, if you bought the property from someone a couple months ago, their prior tenancy will count towards this. So if they've been living there for less than 1 year and it's a month to month, you can terminate it on 30 days notice. It's no longer, if it's more than a year, but less than 2 years, you have to give them a 60 days notice. So it's not, even though it's a month to month lease where the tenant can terminate it on 30 days notice, you must give 60 days notice if they've been living there for more than 1 year. And if they've been there for more than 2 years, you have to give them 90 days notice. Now this is termination both of a month-to-month tenancy and also notice that you're not renewing their lease. So if their lease is expiring on December 31st, 2021, you have to give them notification prior to October 1st, 2021, that you are not renewing their lease. So otherwise, they can continue on living there if you do not give them notice of non-renewal. Another major change is rent for purposes of an eviction. It does not include late charges, interest, or other fees. So prior to 2019, landlords could evict a tenant for not paying late charges that are provided in the lease, even though they paid all the other charges. Currently, or under the new law, you can only evict a tenant for non-payment of rent. You can't, has to be based on non-payment of rent. It can't be based just alone on non-payment of late charges, interest, or other fees, such as repair fees. Another major change that affects your ability to keep the security deposit or charge tenants for damages are the required move-in, move-out inspections now. I've always advised of tenants to complete move-in, move-out checklists. That's when, before the tenant moves in, you go through the apartment, note whether the condition of the apartment is satisfactory, needs repair, so forth. They do the same when they move out. Now that is required. Tenants have a right to a move-in inspection before they move in, and if they're asking for any type of repairs, an agreement has to be drawn up. And there's also a move-out inspection required. You have to give them within the final 2 weeks before they vacate. They have a right to a move-out inspection, and you can give them up to 48 hours notice of that. Another major provision that affects your ability to keep the security deposit for non-payment of rent or damages is that security deposits must be returned now within 14 days after a tenant vacates the apartment, which I know may be cumbersome if you have special security deposit accounts set up with your bank about getting the money out of the bank. But you must either return the security deposit within 14 calendar days after they vacate the apartment, or advise them what you're deducting for. So you'd have to have all your estimates and advise them that. If you don't do that, they have a right to return their security deposit regardless of damages that they cause. So you forfeit your right to keep the security deposit if you do not return the not notify them within 14 days of any damages or unpaid rent. At this time, Justin Friedman will be covering updates on the various New York eviction moratoriums.
Thank you very much. So it seems that this area of the law, the only constant is change. Policies are changing seemingly on a daily basis, and it involves a lot of moving parts. First of all, there's the New York legislation, particularly the Emergency Eviction Prevention Act of 2020, which codified a lot of the governor's executive orders that were being issued earlier in the pandemic. There's New York courts administrative orders, which are interpretations of that legislation. And then there are individual court policies, which are interpretations of the interpretations where there's a lot of gray area and a lot of uncertainty and unpredictability as you move from court to court. So the big headline here, though, that a lot of people aren't aware of is that the eviction moratorium was in fact extended to January 15th, 2022. Now, a lot of people hear that and think that that means that they simply cannot evict anyone until after January 15th, 2022. That is not the case. There are workarounds. So that's essentially what we're going to discuss today. And we're going to discuss, how a landlord can go about removing a problem tenant. It depends on a number of different factors. So a landlord's ability to evict a tenant is going to depend, first of all, if it's based on non-payment or holding over. As Bob had mentioned, we found it easier to evict someone on the basis of holdover rather than non-payment. Becomes more difficult for a tenant to assert a hardship in that case. Not that a tenant can't assert a hardship under a holdover, but we've found that holdover evictions are more successful than non-payment. Leading right into that is whether or not a tenant is suffering a financial hardship. If the tenant can demonstrate that he or she is suffering a financial hardship, it's most likely that this is going to be put off until after January 15th. Now, to establish that they are suffering a hardship, the tenant is going to need to submit a hardship declaration, which we will talk about and take a look at later. If the tenant submitted the hardship declaration to the landlord or to the court, the eviction is again going to be postponed until sometime in January. Additionally, now we're dealing with the emergency, the ERAP. So if ERAP application is in, which we will talk about that later, if that is pending, it's likely that the eviction will be put off. Now, all of this can be overcome if the tenant's behavior is causing a nuisance. So a nuisance is described in the statute as intentionally causing significant damage, substantially and persistently infringing upon the use and enjoyment of others, whether that be other tenants, other occupants of the property, potentially other neighbors, or if the tenant is causing a health or safety hazard. And if these allegations can be proven with evidence, there's the potential to get a warrant of eviction well before January 14th. Finally, and most recently, this is one of the recent changes, it will depend on whether when a warrant of eviction was issued. We found that we've gotten warrants of eviction granted. However, they will not be executed if they were issued prior to September 2nd. September 2nd was when the moratorium was extended. So any warrant that was issued prior to September 2nd, but not yet executed, the court is going to require a status hearing to determine whether the same conditions exist that allowed the warrant to be granted in the first place. So if you're out there and you've had a warrant issued prior to September 2nd and it hasn't been executed yet and the court hasn't been in touch with you, so we've also found some of the local courts haven't been in touch with the landlords about the status of the warrant. We've had to rely on the sheriffs or the marshals or whomever is responsible for serving and executing the warrant. That's because a status conference needs to be held before those law enforcement authorities can execute the warrant. So a lot of what the Emergency Eviction and Foreclosure Prevention Act of 2020, a lot of what that's going to require is a whole lot more paper, paper in the filing. We're cycling through some of it right there. But the main thing is that when you serve someone with a notice of termination or a 14-day notice to, those pre-eviction notices to get the ball rolling, you're going to have to submit a hardship declaration. The burden now is on the landlord to submit a hardship declaration that says if you're suffering a financial hardship or some sort of health-related hardship, that this could be put off until January 15th. And this gives the opportunity for the tenant to check a box. That's all they have to do at this point. Eventually, if the landlord wants to contest the hardship, they now can. That's a result of the federal eviction moratorium being turned over. We'll talk about that in a second. Along with the hardship declaration, the notice of termination or 14-day notice is you're going to have to serve a list of 3 legal service providers to give contact information to the tenant as to pro bono attorneys that they can contact to represent them. And these lists are specific to judicial district. We'll show you the one for the 8th Judicial District in a second. But if you go to the New York Court's website, they will have those lists to print out for wherever your property may be. Okay, so that's all just goes in the notice. When it comes time to file the petition, which would normally contain the notice of the petition and the petition outlining the grounds for the eviction. Now you're also going to have to reattach that hardship declaration, list of legal service providers to that, along with an affidavit of service, separate from the affidavit of service of the notice itself, saying that the hardship and the list were also served. What I also should just double back on and mention is, along with the list of legal service providers and the hardship declaration that's initially served with the notice, you need to provide an address or an email address for the tenant to return the hardship declaration and list to. So normally what we do is we put a cover letter on with our address saying, send it here. Now, in the event that they don't return the hardship or to you completed, that's great. You're going to have to provide an affidavit of service, affidavit along with the petition saying that the hardship wasn't returned. And again, that could be one of those workarounds in order to be able to evict someone. If they don't return the hardship, if they make no claim that they have a hardship, the court will grant the warrant eventually. Another workaround is to say that the nuisance exception applies and provide in the affidavit that the tenant is causing a nuisance, the type of nuisance we discussed before. It has to be very specific. The fact that they're not paying rent isn't a nuisance. The fact that you're, sick of taking their phone calls or complaining about repairs, that's not a nuisance. They have to be intentionally destroying your property, bothering others, or causing a health or safety hazard. So you put that in the affidavit saying the exception applies and specifically say what the nuisance is. You don't have to provide evidence of it yet at this point. Finally, and this is new, since the federal eviction moratorium was turned over on due process grounds, you can also put in the affidavit that the landlord has a good faith basis to believe that the hardship that the tenant is claiming does not exist. And if you make that claim, then the court will be obligated to provide a date for a hearing, at which point the tenant will be, have to prove that the hardship exists. Again, this is a road that we don't want to go down because as you'll see when you look at the actual hardship declaration, the bar for hardship is very low, and proving it doesn't exist is going to be difficult. I have an asterisk at the end there. If you do put that in the affidavit that you believe the hardship doesn't exist, you're going to have to include additional document on the filing, on the top of the filing, on top of the notice of petition, this wording that's on the next slide. It's a notice to the tenant that this is a petition to commence an eviction proceeding, and that you're claiming the hardship doesn't exist and asking for a hearing. The wording has to be exactly as it is, and it has to be bigger. It has to be at least 14 point. That has to be the cover letter of your petition on top of the notice petition. When you serve the tenant, that wording has to be there. In addition, in the petition, you're going to have to submit an affidavit or an affirmation from your attorney that this petition is consistent with all of these rules that we just discussed. This is just a form. It's available on the New York Court's website. We have it available here. You can print it out off of the slides when you get the recording. And then finally, you have to provide a notice in Spanish and English that the tenant may be eligible for an extension of a time to respond. We have this form for you as well. And then the next few slides are just going to be these documents that we talked about that you can print off. This is the notice to the tenant that's on top of the hardship declaration, informing the tenants of their rights under the Emergency Eviction Protection Act of 2020, letting them know that they have till January 15th, 2022, potentially, if the exceptions aren't met. This is a change from the previous hardship declaration notice that had the date of September 1st as the end of their, or I'm sorry, that was back when it was in May, the date of May. And so here's the declaration. As you can see, all it is you check a box, and there are very general categories here. As you'll see at the top of page 9, there could just be other reason related to the COVID-19 epidemic that's prohibiting them from, getting a job or obtaining their usual income. It's very general. Again, this is why we don't want to go to hearing on this, because it's going to be difficult to prove any of these things. And then there's also a separate category that vacating the premises, might aggravate a pre-existing condition. So all they have to do is check one of those boxes. If the landlord doesn't contest that, it's going to be postponed until at least after January 15th, provided a nuisance exception doesn't exist. Okay, then after the hardship declaration, I've included the list, a very exhaustive list of resources in the 8th Judicial District, broken down by county. Again, if you're not in the 8th Judicial District, there is on New York Court's website a list just like this, but for your district, that will break down the free legal services by county. If you are in the city of Buffalo and potentially in other cities, they may have their own list. I've included that as well. So that is in Spanish and English, the one Buffalo provides. It's on the next slide. So this is the list that's provided if you're in the city of Buffalo, not the one that I previously showed on those slides. If you use that list instead of this list in the city of Buffalo, you have the potential to have the filing rejected by the court. So again, if you're in the city of Buffalo, make sure you use these lists here. And then finally is the slide with the notice that the tenant may be eligible for an extension of time to respond in Spanish and English. We put this at the end of every petition. Some courts require these pages to be printed off on a color of paper that is not white. Some courts do not have that requirement. Just to be safe, we always print these off in blue. So that is the complete filing. And finally, it's not the complete filing. I thought I was done. This affidavit or affirmation, this is the petitioner's affidavit. If you're doing this on your own, then you would fill out this affidavit before a notary saying that you're in compliance. If you have an attorney doing it for you, there's an affirmation that the attorney will fill out. Again, this is just a form. You can fill in the blanks, and this is attached to the petition as well. So that's the complete package. I mean, these end up being about 30-page filings that need to be served on the tenant. Again, with the affidavit of service needs to indicate, again, that the hardship declaration and the list of free legal service providers was included with the petition. So now you get all that done, you get a date, you get it served, you get to court, a number of things could happen. So if you get there and the tenant shows up and the tenant has an ERAP application in, whether or not the landlord has decided to participate in ERAP, if there's no nuisance allegations, this is going to get pushed off until sometime after January 15th. If there isn't an ERAP application in and the tenant still shows up and doesn't have an attorney, as Bob was saying before, they will be entitled to an adjournment. So never expect these to be resolved at the first appearance. Okay, now even in a best case scenario where a tenant does not show up, you're not going to get a default warrant issued at a first appearance. Even if the tenant is not there, you are going to be required to request a default hearing at the appearance, and then you're going to be required to serve a notice of motion for default hearing on the tenant. So even after you've served them with the petition, you have to serve them again with the notice of a motion for a default hearing. And again, different courts have different requirements as to how this needs to be served. The statute is silent on it. So some courts only require this to be sent to the tenant. I had one judge tell me I could put it on a cocktail napkin and tape it to his door. But I wouldn't recommend doing that because I've been in other courts that will require personal service. So again, paying a process server to go make 3 attempts to serve personally, and if not, then nail and mail. So erring on the side of caution, I would say serve this notice of default pursuant to the statute. Also, some judges will require, in addition to the notice of motion for default, for there to be a affirmation from the attorney or an affidavit from the landlord describing all of the steps that you just went through and verifying that the tenant did not appear. So once this is served on the tenant and you go back to court and the tenant does not appear then for a second time, then you'll get your warrant issued. Now, when the warrant is issued in city courts, they will have their own warrants that should be in compliance with the new law. If you're going to a town or village court, you should bring your own warrant, and the warrant needs to state on it now that either the tenant didn't submit a hardship application or the tenant is ineligible because of the nuisance. Now, in some cases, when it's issued by default or if it's issued by stipulation, that doesn't fall under any of those categories. So if I had judges send me back and say, bring a new warrant that says and or it was a default warrant, or the warrant is being issued pursuant to a stipulation. And again, we discussed earlier about how warrants issued prior to September 2nd won't be executed without a status conference. Just a couple other random notes in terms of court procedure in some counties, including at least Monroe and Seneca County that I know of. No matter where you are in the county, you'll submit your petition perhaps to a town or village court, file it there in Monroe and Seneca County. They will then send the petition to the county court, and the actual hearing will be in the county court. Seneca and Monroe County have consolidated all of their landlord-tenant proceedings in the county court. So if you're in either of those counties, expect to appear in the county court. You'll get notification of that. The petition, though, will still be filed with the local town court. In addition, just very recently, the city of Rochester has consolidated all of their landlord, tenant, and housing issues into one housing court. Hopefully that will help with the efficiency in moving some of these matters through a court that is specifically set aside to deal with landlord, tenant, and housing violation matters. Okay, and just to end on some good news, because this has all been rather complicated, and I apologize if I've spoken too quickly. We'll be taking questions afterwards. But the good news is there is rent relief in the form of ERAP, which is for tenants to apply, and the landlords also have to participate. And the eligibility for that, it's pretty wide eligibility. It could be from up to 120% of the median income. So you could be coming in at over the median income. You'll still be eligible for that. And now, in terms of priorities, as of tomorrow, if you are up to 120% over the median income, you'll be eligible for that as a tenant. And again, this covers rent from March 13th, 2020 onward, up to 12 months past rent and up to 3 months of future rent. There is an update that in many counties, the funds are close to being exhausted, which I found surprising when I saw that today. So you should apply as soon as possible. That does not apply to Erie, Niagara, and Oneida counties. There are still plenty of funds available in those counties. So tenants should be encouraged to apply for that. Again, if the tenant applies and the landlord does not want to participate, that's not going to stop the adjournment of these matters until January 15th. Now, if the tenant is being uncooperative and the landlord wishes to apply and has let the tenant know 2 times in writing and 1 time verbally, the landlord can apply on his or her own for fundings through the Landlord Rental Assistance Program, which is LRAP. We have the links to those. It's very intuitive and user-friendly website. Surprisingly, lets you know just what documents you need to upload. In addition, for landlords who had tenants leave prior to these funds becoming available, you can apply for that without having had to put your tenants on notice about ERAP if your tenants left before ERAP was a thing. So we encourage all landlords who have been left with rent owed to them to apply for LRAP. So that's all I have for now. I'm going to turn it back over to Bob.
Thank you. Just a few disadvantages for landlords that you need to keep in mind with ERAP are that if the tenant applies, you cannot proceed with a non-payment eviction until its determination has been made whether or not they are eligible. If you do accept rental assistance, you'll have to waive late fees. You can't increase the rent for 1 year from the first payment. Can't evict the tenant for expired lease or holdover for 1 year after the first payment is received. And with ERAP, if you're uncooperative and can't be located for 21 days, the payments will be sent directly to the tenant. So as far as being able to collect rent and damages, all these moratoriums, all the various moratoriums over the past year and a half, those are not cancellation of rent. Tenants still owe the rent, even though there had been moratoriums. And you've always still had a right to sue for and collect the rent, but there's been restrictions on you being able to evict the tenant for non-payment. As far as being able to collect for damages, move in, move out checklists can be to your advantage to prove damages that the tenant had made. I also have always recommended that you take photos and videos of the interior of the apartment before and after the tenant has lived there, because if there are any property damages, it's going to be your burden to prove that the tenant caused those damages and what the condition of the apartment was before the tenant moved in. And as I said, that these move in, move out checklists are now required by the 2019 Tenant Protection Act. A few things to keep in mind with leases is that if you do have tenants that don't meet your income requirements, and you must consider all income regardless of what the source of it is now. You can't discriminate against tenants on the basis of what their income is. But if you do have tenants that don't meet your financial criteria, you should have guarantors sign to guaranteeing payment. First of all, you're more likely to be paid on time when the guarantors credit is on the line, and you can sue the guarantors regardless of the moratoriums for non-payment of rent and for damages. Provisions in your your lease for added rent, such as late fees, repair fees, and so forth. As I said, you can charge for late fees still, but there is limitations on the amount. Still, it's still good to have late charges in your lease to give your tenants an incentive to pay the rent if they're 6 or more days late with their rent. Attorney's fees should be in your leases, even though you may not, as I stated earlier, even though you may not be able to recover your attorney's fees as part of the eviction action judgment, you could sue for attorney's fees if you later use small claims court or other courts to collect unpaid rent or damages. Those of you who are concerned about about tenants allowing additional people to move into the apartment, which they do have the right to have additional occupants move in. If you're and you're paying utilities, if you're concerned about that, then your lease should provide that you can increase the rent if or charge additional for increases in your utility costs, such as electric and gas and water. Security deposits. Unfortunately, can still be charged. They cannot exceed the amount of the monthly rent. I used to recommend charging additional. Before 2019, I would recommend charging security deposits in greater than the rental amount to have sort of buffer there, but you're no longer allowed to charge security deposits in excess of the monthly rent, and you can no longer collect last month's rent, security deposits, and so forth in advance of when the tenant moves in, which puts a landlord at a disadvantage even more so. Some landlords use confessions of judgment. You can check with us for that, where a tenant agrees that a judgment be filed against him or her if the rent is not paid. This eliminates the need for you to have to find and serve the tenant. Something to keep in mind, if you ever have anyone sign on behalf of someone else as their power of attorney, that power of attorney is not responsible for the rent. They're just signing as an agent. So if you want someone other than the tenant to be responsible for the rent, and you can require the guarantor to have a rental application also, then they have to be designated as a guarantor of the rent. You're required to give receipts for rent if the tenants pay in any form other than a personal check, if they pay by money order or by cash, you're required to give them a rental receipt and keep those records. We have issues that come up with upon tenants dying. A number of issues arise, and the tenant's estate is still responsible for the remainder of the term of the lease of the tenant who died. The executor or administrator would have to find a tenant to take over the remainder of the lease. If there's any unpaid rent or damage to the apartment, you as a landlord can file a notice of claim with the county surrogates court if an estate is open for the tenant. So landlords run into issues when a tenant dies, and so-called relatives or people that claim to be relatives request access to the apartment. Technically, the only person that has a right to access the apartment of a deceased tenant would be the executor named in their will. If they have no will, it would be the administrator of the estate. If they have no known relatives, it may be the county public administrator would have a right to enter the apartment. So certainly it may not be your duty to keep people out of the apartment, but you should not be giving access to unauthorized people to the apartment who do not have keys and are asking access to the apartment. There are certain procedures that you can follow. If no one comes forth claiming to be a representative of the estate, there are procedures that you can follow in your local courts to gain control of the apartment. So you certainly don't have a right to empty the tenant's apartment without going to court or without having an administrator or executor take possession of the assets. And the executor or the administrator does not have any powers until they're provided with certificates from the surrogates court. So just the executor presenting a will is not proof that they have actually been appointed as an executor. So if you do run into these situations about unpaid rent, emptying the apartment and so forth, consult with your attorney to find out the best path to take to recover the apartment and recover your costs. So various defenses that tenants may have to evictions and to paying rent. One of those is the breach of the warranty of habitability, and that is on all residential properties. There's a warranty that the apartment is safe and not a danger to the tenant's life, health, or safety. If it is, if there are dangerous conditions, unhealthy conditions, then the tenant may have a right to withhold their rent, or they may have a right to recover rent that they've paid in the past, and it could be a defense to an eviction proceeding. No matter what your lease says, the tenant cannot give up their right to have a habitable apartment, and that is for residential properties only. So as far as getting a judgment through an eviction proceeding for unpaid rent, you can't get property damage. You can't get a money judgment for property damage to an eviction proceeding, but you can get a money judgment if the tenant shows up or if the tenant's properly served a judgment for unpaid rent. And the jurisdiction of the courts to grant that judgment is unlimited. So even though your town or village court may only have jurisdiction of $3,000 for evictions, it's unlimited. If the tenant owes you $25,000, you can recover that judgment as part of an eviction proceeding, not part of the small claims court. We'll talk about there's limitations on the amounts with small claims court. But if you do get a judgment against the tenant for unpaid rent, then you should get a transcript of that judgment from the court and file it with your county clerk as a judgment, because that will do two things by filing a transcript of judgment with your county clerk. First off, it will it'll show up on their credit report. And secondly, it will give you the rights to enforce it through property execution and so forth. And also those judgments will be a lien against any real estate that the tenant owns within the next 10 years unless you renew it. So judgment liens become liens against real estate for a period of 10 years. So you would ask your city or town or village court to issue a transcript of judgment, and then you would file that with the county clerk. So small claims court, there is, if you are a if you own your property as a limited liability company or a corporation, you can only use commercial claims. You can't use regular small claims, and commercial claims are only available in city courts. However, city courts do have countywide jurisdiction. So if the person you are suing is residing or has an office in that particular county, you can file your commercial claims in that city court in that county. City courts have small claims jurisdictions of up to $5,000. Your town and village courts only have jurisdictions of $3,000 for small claims I'm talking about. So for city courts, small claims are $5,000. And for small claims, if you want to sue a regular part of city courts, not small claims, but regular civil part, you can sue up to $16,000. If you have something in excess of that, then you would have to go to county or Supreme Court if you're suing a tenant for anything in excess of that, if it's a civil action as opposed to an eviction. So skip tracing has been made a little bit easier now in finding your tenants to collect on the judgments. Obtaining the judgment may be the easy part. The tough part is collecting it, and most of your judgments are going to be uncollectible. So it's best that you work something out with a tenant to obtain the money from him without having to chase him down. During the pandemic, many landlords worked out rental modifications with their tenants to have them pay less rent, but to promise payments per schedule. So as far as finding your tenants, it's all your obligation to do that. That's your responsibility. The courts, there are no debtor prisons. It's not up to the courts to find your tenants to collect on it. So just because you have a judgment, most judgments will be useless unless the tenant has full-time employment, has a house, but for the most part, someone that is unemployed, has no real estate, has no other assets, probably the judgment will probably be uncollectible. Judgments are good for 20 years. Unlike the lien against the liens of real estate are good for 10 years, the judgment itself is good for 20 years. So you have 20 years unless you renew the judgment to collect on the judgment. So, one way of finding your tenant or where the tenant may be is by using rental applications, and you can obtain information from the rental application regarding possibly where names of relatives or where they lived or where they're working. So these are all possibilities of finding the tenants in order to collect on the judgment. So you can also serve an information subpoena on the tenant, requiring him or her to disclose all their assets and employment and so forth. It can be served on a tenant. Theoretically, a tenant could be put in jail for not answering the subpoena because it is a court process. A judge would rarely probably put someone in prison until they answer the information subpoena. So very often it's not too enforceable, but you serve a question and answers form on the tenant for them to reveal their asset and income information. So as far as collecting on the judgment, through the sheriff's department or the marshal's department, marshal's office, number of ways of doing that. Property execution, such as seizing their property. Other than you can't seize household items, there's certain things that are exempt. Property execution could be on a car, having the sheriff seize their car. Very often it's not worthwhile to go after a car because they may have a car may not be worth enough to justify all the sheriff's fees. The car may be leased, or they may have a car loan. So if it's leased or it has a car loan, then no one's going to touch it. Income execution. If they're, you can garnish someone's wages as long as there aren't any prior garnishments. If they're making if they're working at least 30 hours at minimum wage. So whatever the current minimum wage is times 30, they have to be making at least that much before you can garnish 10% of their wages, which it's probably one of the more successful ways of collecting judgments is through wage garnishments. It's easier these days to verify their employment. Execution with notice, as far as seizing bank accounts, it's first you can serve a restraining notice on a bank. You don't have to know the name of the bank or their account number. You can have an attorney serve a restraint on where they bank. There again, you can seize Social Security benefits or pension benefits. There's a limitation on, and it's a pretty involved procedure to be able to restrain and execute on bank accounts. So you restrain the bank account first, you serve a subpoena on the bank will tell you how much is in the account, and then you have the sheriff serve an execution with notice on the bank so that the funds are turned over to the sheriff or the marshal. Those can be somewhat successful if they have enough funds in their accounts. Probably more successful if you're going against a commercial tenant. So we will provide you with links to our website so you can obtain additional information, and you want a subscription to our newsletter with updates a few times a year. And we have past videos and webinars on there with landlord tenant law. So if you can complete that, if you still have any other questions, you can either call us or you can submit our contact form on our website. And we do have a few minutes left here.
There are some questions that I said I was going to answer live that were put in while you were speaking, just because I think some important points were brought up that I may have glossed over. First of all, we don't practice in New York City, and there are some variations in the laws there. Someone from New York City wrote in to say that in New York City, small claims court is up to $10,000 now.
Right.
So another important question someone asked about an exception to ERAP about a prohibition on holdovers is if the owner's child wants to move in, are they still prohibited from initiating a holdover proceeding? That is one exception. If there is an immediate relative who wants to move in and you can prove that, you can get around that prohibition on holdover evictions for tenants who have applied for ERAP. Someone asked if everything we discussed applies to commercial tenancies. In particular, are they shielded from the moratorium if they haven't been paying their rent? And again, that would depend on if they can establish a hardship. You still have to serve a hardship declaration on commercial tenants. And if they indicate there's a hardship and they can establish that, then they will be shielded from the moratorium. Somebody asked if it was sufficient to serve a notice of motion for default in the same way that other motions are served under the CPLR. Again, that depends on the court. I think a good practice would be you're making the oral request for a motion date in court, ask the judge what the court prefers as far as service goes. Sometimes they'll be upfront about it and say you have to personally serve it, or just certified mail is fine. sometimes the judges will be cute and say, look at the statute, and the statute doesn't tell you, so that's not helpful. In that case, I would just serve it pursuant to the real property law rather than the civil procedure law. And then again, someone asked if smoking could be considered a nuisance. I think it could be considered a nuisance. It's all going to depend on if you can establish that with evidence other than your own testimony. The statute says that the landlord's testimony is not sufficient. You need evidence. So if your neighbor's complaining about smoke, I would say bring the neighbor into court to put on the record that they are being disturbed by the tenant smoking. And then somebody, Bob, asked for clarification about the number of days that the landlord has to respond before the ERAP will go to the tenant. That is 21 days, correct? Somebody
Yes.
said that they saw somewhere that was 180. I'm not sure where that's coming from.
I also see an interesting comment from Faye regarding tenants that have withheld paying rent that are planning to claim bankruptcy. How does that play into what we've been talking about today?
Well, that would prevent, if they do file, once they do file for bankruptcy, that there would be a stay. Landlords can't take any action against them to collect the rent, but that they would still be able to evict them, though.
Okay.
But that would wipe out the rent that's due.
Yeah, and then the landlord would then not receive those funds, or would there be a way for them to get it through like an emergency rental assistance program?
Once the tenant has filed bankruptcy,
Or is the landlord never going to see that money?
most likely they would never see the money, correct?
I see. Okay.
So a question here about building is in the name of an LLC. How do you collect money judgment and what are the minimums? Well, if the building is in the name of if your building is in the name of the LLC and the lease is in the name of the LLC, which is what I recommend, that if you do have a real estate in the name of the LLC to maximize the protection of the LLC, the lease should be in there too. You would still be able to collect the money judgment the same as anyone else. It's just that the only difference is you couldn't use regular small claims court to collect on that judgment. I mean, to sue for the rent, you'd have, if you're going to use small claims court, you'd have to use commercial claims, or you're free to use regular civil parts of the courts. The LLC could use any of the other courts, county supreme, city courts, other than regular small claims court in a village or town court. If they want to use a village or town court to collect, they could do so. It would be a regular civil action, not a small claims action in a village or town court, which would involve the service of a summons with notice or a summons and complaint, and the regular procedures where the tenant could answer in writing, and it could be delayed quite a bit more than a small claims case.
All right. Also from Michael in the chat, can you recommend a private investigator in New York City or in New York? I need skip tracing service to determine where my ex-tenant moved to sue for unpaid rent. Do you have any suggestions? Maybe you know one, or maybe have just a suggestion as to how to find a good one. Any thoughts there?
I don't. I can possibly give them, if they want to contact me, I could possibly give them some ideas how to find one.
Okay, great. Michael, I have your email, so I'll go ahead and send you a follow-up on that. Also, Mr. or Mrs. Davis saying that this was pretty depressing. So I do have to say it is quite tenant friendly, what we're seeing here in New York, especially. But at least we're seeing a little bit of hope coming around the corner now that January 15th seems to be hopefully the final extension, I think. I mean, I don't see any other questions. Oh, well, Faye asking about probability of extension. So I wish we all could, tell the future and have a crystal ball in front of us where we could say for sure that it wouldn't be changed. But do you have any opinions as to how likely it is that it may get extended again? Have you heard about anything that we may not know?
I haven't heard anything, but based on the history here, it's probably a good likelihood. I know apparently, Governor Hochul and the legislature in general are very pro-tenant. Unfortunately, I don't foresee things getting any better with the COVID rates over the next couple of months. So I would say it could be more likely than not that it will be extended again. I mean, who thought we would have been at this point, having been extended so many times? But I will, any updates I'll provide in my newsletter or the website about what we hear about what's going on with that. Yeah, we're not that far off from January 15th right now. So they apparently do these things at the very last minute. A year ago, they passed that the emergency, the one emergency provision was passed with no notice. I think it was December 28th of 2020. So very often there's very little advance notice, and then in January they dumped all these procedures on us about handling evictions. So it's literally changing just about every day.
Wow.
Even this most recent extension, there was a gap.
Yeah, there was a gap. Yes, the one in the summer, right? Yeah. Yeah, because the executive order,
there was sort of bad optics, putting people out in the street at that time of year. I would just say I'm not hopeful.
Yeah.
I'm pleasantly surprised, but I just wouldn't get your hopes up about the moratorium not being extended.
And plus with the federal government too, they may step in. That's been challenged, and there haven't been too many successful challenges against the federal eviction moratoriums. So I guess it's not very optimistic. We're not too optimistic to make the best of it.
Well, I guess you can only do so much right now, but I'm really glad that you guys came on and gave us some insight as to exactly what's changed, so we have a clear picture of the situation. I'd love to have you come back if there are any major updates next year. I'm sure there will be, like you said. Thank you so much for coming on today. I really appreciate this. I think our members really need this information, and hopefully things will get better next year at some point. So with that being said, we can conclude the webinar. I will send everybody the recording tomorrow. I will send any of the links here that have been shared and the PowerPoint slides, Robert and Justin's contact information, so you can follow up with them if you need additional help. Again, thank you so much for coming on to speak today.
And thank you for hosting this.
Of course. Take care, everyone. Have a wonderful weekend. Bye.
Bye.